I am Barrister Mohammad Fariduddin, and today I'll discuss the British Constitution. By British Constitution, I mean the Constitution of the United Kingdom. The British Constitution is said to be an unwritten constitution. It means that the constitutional rules of the United Kingdom are not found in any single text. Rather, they can be found in different sources, including statutes, case laws, international treaties, and constitutional conventions. It is very important to remember that unwritten constitution does not mean that the constitutional rules cannot be found in any written form. On the contrary, almost all the constitutional rules of the United Kingdom are written down in various sources. It is called unwritten constitution because those rules cannot be found in any single written document called Constitution of the United Kingdom. The sources of the constitutional rules of the United Kingdom are statutes, common laws, international treaties, and constitutional conventions. I will discuss each of them. Acts of Parliament are passed by the Parliament of the United Kingdom. However, Parliament does not only mean the elected House of Commons. Elected House of Commons and unelected House of Lords together form the Parliament of the United Kingdom. In addition, the royal assent of the Crown is required before a parliamentary act or legislation can be passed. Before passing as a legislation, the draft of the proposed legislation is called bill. Bills are drafted by the Parliamentary Council, also called Parliamentary Draftsman of Parliamentary Council Office. Then the bill is scrutinized by politicians during the legislative process. Certain steps or procedures have to be followed before a draft bill can finally be passed as a legislation. Those steps are first reading, second reading, committee stage, report stage, third reading. Then the whole process repeats again in the House of Lords. And after completion of all these stages, the bill is presented before the monarch for royal assent. After getting royal assent, the bill becomes a legislation or act of parliament. Such laws are also called statutes. Some British statutes contain constitutional rules, but it is important to remember that not all statutes contain constitutional rules. But in the United Kingdom, neither the statutes containing constitutional rules have any higher formal status, nor there is any special procedure for passing such statutes containing constitutional rules. Anthony King, in his book, namely, Does the United Kingdom Still Have a Constitution?, published in 2001, defined constitutional statutes as important rules that regulate the relations among the different parts of the government of a given country, and also the relations between the different parts of the government and the people of the country. Lord Justice Laws in Thorburn versus Sunderland City Council, reported in 2003, defined constitutional statutes as which conditions the legal relationship between citizen and state in some general overreaching manner, or enlarges or diminishes the scope of what we would now regard as fundamental constitutional rights. Examples of some constitutional statutes in the United Kingdom are Magna Carta 1297, Bill of Rights 1689, Human Rights Act 1998, etc. I will discuss some of them. There is another year of Magna Carta titled 1215, but that was the charter granted by King John, and in 1215 the Magna Carta did not get the status of a statute. Magna Carta got the status of a statute in 1297, and therefore Magna Carta 1297 is the relevant one for discussion of statute as a source of British constitutional rules. Magna Carta 1297 contains proclamation of liberties, including that no free man may be punished except by lawful judgment of his peers or by the law of the land. It also includes that the Crown will sell to no man, will not deny or defer to any man either justice or right. Bill of Rights 1689, which is also a statute with constitutional significance, requires parliamentary approval for the Crown to levy tax and keep a standing army. It also prohibits excessive bail, fines, and illegal and cruel punishments be inflicted. It also affirms the right of trial by jury, and in Article 9 provides a speech or debates or proceedings in Parliament ought to be privileged. Acts of Settlement 1700 requires the monarch to be a member of the Church of England, and this is also a statute with constitutional significance. Parliaments Act 1911 and 1949, which ensures the primacy of the House of Commons over the House of Lords by enabling the Commons to present a bill for royal assent, even if the House of Lords disagree. Supreme Court Act 1981, now renamed as Senior Courts Act 1981, sets out the structure for the courts of England and Wales. It protects judicial independence by making senior judges removable from office only by Her Majesty on an address presented to her by both houses of the Parliament. Human Rights Act 1998 brings home provisions from the European Convention of Human Rights and Fundamental Rights. Constitutional Reform Act 2005 reformed the office of the Lord Chancellor, created the United Kingdom Supreme Court, replacing the Appellate Committee of the House of Lords, and introduced new system of judicial appointments for England and Wales. Therefore, this is also a statute which contains constitutional rules. Now, from these examples, you may have an idea that in the United Kingdom, statutes may contain constitutional rules, and also have an idea about the procedure of passing legislations in the United Kingdom. The common law is another source of the British constitutional rules. The common law or judgment laws are pronounced by the judges of the higher courts of the United Kingdom's three jurisdictions, that is to say, England and Wales together, Scotland and Northern Ireland. The judgments of the United Kingdom Supreme Court is also a source of this kind. The judges, while adjudicating disputes between parties, also draw conclusions about law points, and the laws declared by the judges of such superior courts are laws and may contain constitutional rules. Undoubtedly, the judges of the higher courts of the United Kingdom have made significant contributions to the development of the British constitutional rules. For example, in Entick versus Carrington, this is an old case decided in 1765. The Lord Chief Justice held that the King's messengers trespassed on Entick's land when they entered his house to search for seditious papers without any specific legal authority to do so. The case is significant because it upheld the citizen's fundamental rights of privacy of home and his right to property. It established that even the government official cannot enter a citizen's home without his permission, unless there is any specific law authorizing the official to do so. In the case of proclamations, it is also an old case decided back in 1611. In this case, what happened was that through royal proclamations, King James I wanted to prevent the erection of new buildings in London. He also tried to stop the making of stock of wheat. The Parliament opposed the King's decisions. The matter was referred to the court for decision. The issue was whether the royal prerogative can be used to change the existing laws without the consent of the Parliament. The Lord Chief Justice Coke held that the King had no power to make new laws, and he could only make new laws through Parliament. This is a significant constitutional rulings at that point of time. International treaties ratified by the United Kingdom are another sources of constitutional rules of the United Kingdom. International treaties are negotiated and entered into by the diplomats who are, or at least should be, politically neutral officials working on behalf of the government. An example of international treaties in the United Kingdom is European Convention of Human Rights, which is an international treaty between 47 states, and the United Kingdom is also a party to that convention. Constitutional conventions are also sources of constitutional rules, and they are made by different types of political actors, but notably politicians and the Queen. Conventions are not laws in a strict sense. They are essentially political practices. But not all practices are conventions. Practice becomes convention when there are precedents for the practice and a good reason for the practice which is considered binding by those involved in the practice. Dicey was a very famous writer on British Constitution. According to him, conventions are those customary rules that determine the way in which the discretionary power of the executive should be used. Dicey, in his book, namely Introduction to the Study of the Law of the Constitution, a very old book written back in 1885. In that book, in page 23 and 24, he said that the rules which make up constitutional law, as the term is used in England, include two sets of principles or maxims of a totally different character. The one set of rules are, in the strictest sense, laws, since they are rules, whether written or unwritten, whether enacted by statute or derived from the mass of custom, tradition, or judgment maxims known to the common law, are enforced by the courts. These rules constitute constitutional law in the proper sense of the term, and may, for the sake of distinction, be called collectively the law of the Constitution. The other set of the rules constitutes or consists of conventions, understanding, habits, or practices, which, though they may regulate the conduct of several members of sovereign powers, of the ministry, of the officials, are not in reality laws at all, since they are not enforced by the courts. This proportion of constitutional law may, for the sake of the distinction, be termed as conventions of the Constitution or constitutional morality. You know that morality are not enforced by the courts. Only laws are. Conventions are social rules of a constitutional character which govern the relations between political parties and the institutions of the government, regulating the manner in which government is to be conducted. According to Sir Ivor Jennings, we have to ask ourselves three questions. First, what are the precedents? Secondly, do the actors in the precedent believe that they were bound by the rule? And thirdly, is there a reason for the rule? The Cabinet Manual defines conventions as rules of constitutional practice that are regarded as binding in operation but not in law. Some examples of constitutional conventions in the United Kingdom are that by convention, the sovereign, that means the monarch, does not become publicly involved in party politics of the government. Another example is that the roles of the Prime Minister and Cabinet are largely governed by conventions. Another example, by modern convention, the Prime Minister always sits in the House of Commons. There is no law behind that, but that is a convention. There is also a convention that an individual will be a minister only if he or she is a member of the House of Commons or the House of Lords. By convention, cabinet and cabinet committees take decisions which are binding on members of the government. In 2011, the government acknowledged that a convention had developed in Parliament that before troops were committed, the House of Commons should have an opportunity to debate the matter, and said that it proposed to observe that convention except when there was an emergency and such action would not be appropriate. That is all for today. Thank you for listening.